Okay, revision of the complete chapter of directors, appointment and qualification of directors, containing section number 149 to 172. So we have a lot of sections along with the relevant rules, and we are going to revise the same now. Let's begin. First thing is, what do you mean by directors? See, directors are someone who are appointed to the board of the directors of the company. Directors do not have any power individually, they have collectively power, right? They have collective power, which is, you can say, the board of directors or the directors or the board. These all three terms are synonymously used, and they have the power. Why do we need directors? Because company is an artificial person and company cannot run on its own, so we need someone to direct the company. All the company directions cannot decisions, actions, directions, they cannot be done by the shareholders who are the investors of the company. Simple reason being because they are in huge number and everyone cannot be interfering in the management of the company. That's why we need directors to manage the company. So Companies Act has divided the whole powers of company into two authorities. One is the board of directors and other is shareholders. So at times we need permission from shareholders, and the day-to-day management is being handled by the board of directors. Section 149 mandates that every company must have board of directors. Section 149 tells us that minimum number of directors and maximum number of directors, what are they? Minimum number of directors you need 1, 2 and 3. 1, 2 and 3. 1 for OPC, 2 for private and 3 for public. And maximum number of directors for all types of companies is 15. This 15 can be increased. That means a company may have even 20 directors provided it passes a special resolution in this regard. So by passing SR, the maximum number of directors can be increased by any company, right? This particular requirement does not apply to Section 8 company as well as government company, not applicable to government and Section 8 company, right? That means if a Section 8 company wants to have 20 directors, it can have without even passing special resolution, So minimum 1, 2 and 3, maximum 15, which can be increased. Now, that was the first proviso. This was the first proviso. It can be increased by passing SR. Second proviso to Section 149(1). So we are talking about one subsection and its second proviso, which is very important. That's why you must learn this second proviso to Section 149(1). Now, what does it mean and what does it talk about? It talks about woman director. Every company needs a woman director, ma'am? No. If it is a private company, there are 2 directors just, out of which one should be woman. This will be harsh on the directors, harsh on the companies. So this is not the requirement which has been imposed by the Act. What has been imposed is that certain set of companies need at least one woman director. You are such a huge company, you have so many board of directors, out of which at least one director can be a woman director. So this is the mandatory requirement which is imposed on listed company, and listed company means listed public company only pursuant to the definition, pursuant to amendment in Section 2 clause 52 definition of listed company, which I'm not discussing here again right now. And if it is other type of public company, then it has to satisfy either of the 2 criteria. Paid up capital more than or equal to 100 crores or turnover more than or equal to 300 crores. Fine. So if it's a listed company, one woman director must. If it is an unlisted public company, if you come under these 2 categories, any of these 2 categories, then you must have one woman director. Fine, ma'am. Now, if it is a new company, newly incorporated company, and it's paid up capital, the turnover will not be, you will not be able to get to know turnover within 6 months of incorporation undoubtedly, but yes, the paid up capital and the listed criteria it may meet. So the whole intention is that the company pre-hand knows that I have this requirement of woman director, and so it has to appoint woman director within 6 months of incorporation. Otherwise, we don't have any specific clarification or law given as to if the threshold increases by when women directors should be appointed, right? All the directors are being appointed in general meeting, and so this woman director will also be appointed. If we look at the financials, and if we find the financials, yes, it is crossing the threshold, thereafter this will be appointed. But what if it is a listed company and a woman director was appointed for a tenure of 5 years, but before that only the woman director died? This gives rise to intermittent vacancy, because if it is not filled, it has to be filled. Because if the woman director has died, there is no woman director, and it is non-compliance of law, so it must be filled. Who has the power to fill it? The board has been conferred the power to fill it. By when? Immediate next board meeting or 3 months, whichever is later. So intermittent vacancy has to be filled within this particular time limit. Okay, within this particular time limit. Now, section 149(3), resident director. This is for all types of companies. Even if you are a private company, you are a public company, or a one-person company, you need at least a resident director. Who is a resident director? Someone who stays in India. For how long? For more than or equal to 182 days in previous financial year. More than or equal to, that means if a person stays for even 182 days, he will be called as a resident. He will be called as a resident. So a director who is also a resident of India is known as resident director, and every company must have at least one resident director. Fine. Every company must have at least one resident director. Now, basically, if you try to recall, there are 2 types of directors. One are executive directors and one are non-executive directors. Executive directors who are in the whole time employment of the company, non-executive directors who are not in the employment of the company, that is independent director or part-time director. And executive directors, we have example managing director, whole-time director, right? Ma'am, women director have to be appointed as executive or non-executive. It can be appointed either ways. It's not a requirement that they have to be appointed as executive only. No, even if an independent director on the board of a company is a woman, it is sufficient compliance for second proviso of section 149(1). Okay. Likewise, ma'am, the resident director, has it to be executive only? No. Again, no such requirement has been given. So it can be executive, it can be non-executive, that does not matter. But every company must have at least one resident director. Okay, I hope that is clear. Fine, ma'am. So we know the requirement of directors. Now, how do we appoint directors? See, section 149 is not over yet. It has a huge part of independent director, which we will do a little later. Why? Because I teach you in that manner only in the regular class as well, right? So we will revise it also in the same manner. Now we are talking about the appointment of directors. How the directors are going to be appointed. See, the directors are to be appointed by members, by shareholders in general meeting. That is what section 152 tells us, right? However, in certain cases it can be appointed by the board of directors also, it can be appointed by NCLT also, and it can be appointed otherwise also. So we will discuss how can we appoint the directors. Section 152 gives us 3 things. How first directors are going to be appointed, the requirements of being a director, and the rotation of directors. So it has 3 concepts involved in it. Fine, ma'am. Who can become a director? An individual. A company cannot become a director. An individual who is holding in, who is not disqualified, who has given his consent, right? And who has furnished MBB1, right? So such a person can be appointed as the director of the company. Fine. Supposedly I fulfill all this criteria. What are the methods? How can I be appointed as a director in the company? The appointment of first directors is given in section 152. The appointment of subsequent directors is given in section 160, and the appointment of retiring directors is given in again section 152. So that's how the appointment is spread over different sections. Okay, ma'am. So every director who has to be appointed to the board of the company must have DIN. What is DIN? It is an identification number which defines who you are, right? So anyone who wants to become a director in a company must have DIN, director's identification number. Without DIN, you cannot be appointed as a director in the company. So you must have DIN. How do you get it? There are two sources of obtaining DIN, DIR 3 and SPICE Plus. We'll read about this later. Okay, fine, ma'am. So you obtain DIN, you give this DIN, and you give a declaration that you're not disqualified, DIR 8. You give your consent, DIR 12, to the company. The company in turns file form DIR 12 for your appointment within 30 days of appointment, right? Section 170 mandates the requirement of filing return, DIR 12, for appointment and wherever there is change in the appointment or change in the directorship or KMP. Okay, fine, ma'am. So anyone who is an individual, anyone who has DIN, anyone who is not disqualified, anyone who gives the consent can be appointed as the director in general meeting by the shareholders unless otherwise provided in the act. So something else can also be provided in the act. In that case, that will apply, but otherwise this is going to be the appointment. However, for the first directors, we cannot wait till general meeting because we are in a hurry. We need directors immediately when the incorporation happens, right? Because we cannot, for one day also, who will manage the company? To call general meeting, who will call the general meeting? So we need directors as and when the incorporation takes place, and that's why the first directors of the company, the appointment cannot be deferred. We need immediate appointment of the same. So what is given? According to section number 152, the names should be mentioned in the articles of association. So the articles of association are going to clearly specify that these will be the first directors of the company. Supposedly the articles of association don't specify. They will specify the manner. How will they be appointed? Supposedly they don't even specify that. So we will check whether table F can be applied or not. If we have specifically striked out table F that it shall not apply, then it shall not apply. Otherwise, it will be applicable if our articles are silent. What is table F? Table F is the model articles of association for a company limited by shares. So if our articles give the name Mr. X and Y will be the first directors, they will be. If it has given the manner, they will be elected in such a manner, elect in that manner. If first 2 points are not applicable, table F will apply. What does table F tell us? Table F tell us that it will be decided by the subscribers. It will be decided by the subscribers, whoever has subscribed to the memorandum. Supposedly, no name is given in articles. We don't say provide the manner, and we say that the table F shall not apply. In that case, the individual subscribers become the first directors of the company. See, the subscribers may be individual, they may not be individual. A company can become the member of another company, right? So maybe on the memorandum of association of that company, a company has signed, right? A company's common seal is affixed or their representatives have signed. Quite possible. A company cannot become the director for another company. Only individuals can become the director, because again company will be an artificial person. So all the individual subscribers become the first directors of the company. Okay, fine, ma'am. First directors are going to hold office till the ensuing general meeting, and after that they can be reappointed or they may leave. If they want to be appointed again, they have to give their candidature. Because for appointment in general meeting, how appointment at general meeting is going to happen? When you give your candidature under section 160, your name is proposed, and general meeting, the shareholders pass OR and appoint you as a director. So now that is going to happen. Fine, ma'am. And after that, you can be appointed as rotational director or non-rotational director in case you are a director of a public company. If you are a director of a private company, you can be permanent directors also, that's not a problem. But if we are talking about the directorship of public companies, then you can be appointed either as rotational director or as non-rotational director. Fine, ma'am. Now, before I move to this particular part, DIR 2, that is the consent part, it is not required in case of not-for-profit organizations, that is not-for-profit companies, as well as for government companies. So they have this exemption from filing DIR 2. Okay. Now, if we are talking about a public company, from the total number of directors, minus your independent directors. Supposedly, a company has total 14 directors and 5 are independent directors, 9 are left. Out of this 9, 2/3 of 9, that is equal to 6, will be rotational directors. And out of the 6, 1/3, that is equal to 2, will be retiring. Will retire at every annual general meeting. Right? So, whatever is your total number of directors in a public company, it's 2/3 have to be, at least it's 2/3 have to be rotational director, whose office is going to be determined by rotation, right? Out of this 2/3, 1/3 is going to retire at every annual general meeting, right? So here in this case, as on our example, 2 directors will retire at every annual general meeting. How they will retire? The person who has been in the office for the longest will retire first. Supposedly 2 people have been appointed on the same day, they will mutually decide who is going to retire in this general meeting. If they cannot decide, then some lots will be drawn. And they will decide. Okay, they will decide. Fine. Supposedly, they have to retire at general meeting. That means they will go. They can come back also, but the chances are they will go also, right? So they can go, they can come back. Supposedly the directors did not call general meeting. Can they continue? They cannot. If AGM is not held, they will have to vacate the office on the last day. AGM ought to have been held. If AGM is held, then the 2 directors, that is 1/3 of the rotational directors, will retire. They can be reappointed, or in their place someone else can be appointed, or the company may resolve that they don't want to fill the vacancy. Either of the three will happen. Supposedly none of the resolution is passed, then the AGM will be adjourned. It will not be conclusion of AGM will be adjourned. When AGM is adjourned and the vacancy is not even filled at the adjourned AGM, it amounts to automatic reappointment of the retiring director. That means he will be automatically reappointed. But there are certain cases of exception where he will not be treated as reappointed. Supposedly Mr. X is retiring and Mr. X has clearly said that I don't want to be reappointed. So he has expressed his unwillingness in writing that he doesn't want to be reappointed. We cannot reappoint him. Supposedly he is disqualified. He has become of unsound mind. How can we appoint him? Specifically in the act is written that we need OR or SR for his appointment. We cannot appoint him. There is contravention of section 162. When Mr. X was appointed, his appointment was only void. That means he was appointed through a single resolution, wherein appointment was needed by a separate resolution. 2 appointments were made by a single resolution. So it amounted to contravention of section 162. Now since your appointment itself was void, you cannot be reappointed. And we tried for your reappointment. So we proposed a resolution in front of the members to reappoint you, but this resolution was lost. That means our members do not want you to be reappointed. So no automatic reappointment will apply to you. Okay, fine ma'am. Now there is one more point over here. What does it tell us? See, some public companies may say that no, we want a transparent vision in our company, and we want all our directors to retire at every AGM. So all the directors retire, someone who's good comes back, and the others leave the company. Companies Act tells if you have such strict provisions, way more stricter than what law says, great, follow them. So if your articles say that all the directors are going to retire at annual general meeting, so be it, right? But if they don't say it, then this is something that you are going to follow. This is something that you are going to follow, right? So section 152(6) tells us about rotation, and section 152(7) tells us how the vacancy will be filled pursuant to this retirement of rotational directors. Ma'am, what if they don't follow? If they don't follow these provisions, we have a section 159, which gives us the penalty, Section 159 tells us that if you contravene section 152, this penalty will be attracted. So the penalty is not given in section 152, rather it's given in section 159. The rotation part does not apply to unlisted government company or its subsidiary. Fine. Okay, ma'am. Section 160. Section 160, what is it? It is a section for new candidates. That means, see, who will be the first directors? They will either be the subscribers, or they will be someone who is known to the board. Supposedly, I am incorporating a company and I know an efficient person. I will take his consent and I'll write his name as the first director. So I know that person knows me. That's why he could be the director. But section 160 gives a chance to anyone. If you want to be the director, you can propose your candidature. So anyone can propose candidature. Just to screen out, or just to have those serious applications, there is a deposit, a refundable deposit of 1 lakh. It's not refundable in all cases, but it's refundable in these 2 cases. So what you have to do is, if I am a member and I want to become a director of my company, or if I am not a member, or if I know someone, I can propose his candidature also. So we propose someone's candidature. How do we propose candidature? We give it to the company. We say that we want this particular person to be appointed as a director in the upcoming general meeting. What you have to do is, you have to give a 14 days notice to the company. That means whenever company is going to hold its general meeting, 14 days prior to that, you must give that notice, plus 1 lakh rupee deposit. Now this deposit will be refunded if the person is elected as a director, or even if he is not elected but his votes are 25%, more than 25% of the total votes which have been cast, it shows that he was a serious and eligible candidate. So in this case also the refund is made. Fine. So you serve this notice to the registered office of the company. What does company do? Company sends this notice of candidature at least 7 days before general meeting to all the members. It can be done by sending individual notices or a public advertisement in 2 newspapers, English and vernacular. And it also has to be placed at the website of the company. Fine. So all the members receive this notice that someone has been proposed to be a director. At the annual general meeting, simply by passing ordinary resolution, they can appoint the director, or if the resolution is not passed, the person will not be appointed. The section does not apply to a private company, because in private company, not everyone gets the power that they can nominate themselves. No. It does not even apply to a 100% government company, wholly owned subsidiary of such 100% government company, and section 8 company where election is happening by ballot system, right? Okay, fine, ma'am. In certain cases, you don't need deposit. Why? Or in what cases? In case of independent director. If independent director is proposing his own candidature, independent directors are someone who are anyway highly knowledgeable, highly professional, highly qualified people. You cannot doubt and you cannot say this is not a serious application. Of course, it's damn serious. So they don't need deposits. Moreover, if a person is recommended by board or NRC, probably they are the people who have much knowledge, and if they are recommending someone, he is a deserving candidate only, right? So in this case, you don't need a 1 lakh deposit. Now, supposedly, someone who has retired, a person was appointed as a rotational director in a public company and he retires according to section 152(6). Now he wants to be reappointed. He wants to be reappointed. The question is, do we need to send the notice and 1 lakh deposit under section 160 for his appointment? Answer is no. Section 160 does not apply for the case of reappointment of retiring director. It clearly says that a person who is not a retiring director in terms of section 152 shall also be eligible to be appointed as the director if he gives a notice plus 1 lakh deposit to the company at the registered office, etc., etc. So that's how the process begins. Fine? Okay, ma'am. Now, we know that individuals who are holding DIN and who are not disqualified can be appointed as the director. So the next question comes out is, what is DIN? DIN, Director's Identification Number. How do you obtain DIN? How do you get DIN? DIN can be obtained in two ways. See, the provisions of DIN are covered in section 153 to section 159. 159 is that last penalty part. Any individual who wants to be appointed as a director, you cannot be appointed unless you have DIN. How do you obtain DIN? You can file an application in DIR 3 with these attachments. There is also an option that Spice Plus. Supposedly, I'm forming a new company and I have never been a director of any company. So what choice I have is in Spice Plus only I can fill my details and it is going to work as an integrated form and will also provide me DIN apart from incorporation of the company. Right, so this is also a method of obtaining DIN. Otherwise, the general form and the regular form that we have for DIN is DIR 3. Now, just like you can obtain PAN as and when you need, you cannot obtain DIN as and when you need. For DIN, what is required is that you must be a director of some company. Ma'am, how can we become the director without DIN? You must be proposed to be a director of some company and only then you can obtain for DIN. That means government needs to know that where do you want to be appointed as a director, and then only they will give you DIN. Why? Because in attachments there is a need for board resolution. So the company which is proposing you to be appointed as a director will give a resolution and then only you can submit this application. Once your application is submitted, central government examines your application. Central government examines your application. Just a second. Central government, if they find that your application is not defective, then what are they going to do? They are going to allot you the DIN. But if they find that yes, your application is defective, then they are going to intimate you via mail or via website and you have to rectify the defect within 15 days. So you get a chance to rectify the defect within 15 days. Supposedly the defect is rectified, then again you can be allotted DIN, and if you do not rectify the DIN, then it has to be rejected. Right, so the application will be rejected. Now whatever DIN you have obtained is going to stay with you for your life. No matter in which company you become a director. You become a director in XYZ, PQR, X Limited, Y Limited, doesn't matter. One DIN for all the companies and one DIN for your life. It's not going to change. It's never going to change. Fine. Okay, ma'am. Only one DIN is allowed for every individual. Just like you cannot have a duplicate PAN, you cannot have a duplicate Aadhaar, likewise you also cannot have a duplicate DIN. Okay, So first thing, you make an application for DIN in DIR 3. Second thing, central government allots you the DIN when they find the application is in order. Third thing, you're prohibited to obtain more than one DIN. Okay, whatever DIN you obtain, supposedly if now you want to become the director of any company, you cannot become without DIN. But for the directors who were already directors, before these rules came into picture, before this concept of DIN came, they were already directors. Now they are also being given a time limit that they have 1 month from the receipt of DIN. They have to inform central government. Okay, they have to inform the companies, and the company in turn will inform the ROC. So existing director has to intimate into the company and the company to ROC. That is section 156 and 157. Okay, fine. This is clear. Now any director, if you have DIN, wherever you are quoting that you are the director of ABC Limited or whatever like that, you must state your DIN. Your name is not sufficient. To identify you, we need that DIN. Just like we quote membership number wherever we are doing that, right? CS membership number, CMA membership number, CA membership number, we quote that, right? That is important. So likewise, directors also have to quote their DIN. Okay, fine ma'am. Now tell me ma'am something, that can we surrender our DIN once we have obtained the DIN? Can we surrender the DIN? The answer is no. You cannot surrender the DIN just like that. Supposedly, I have worked as a director in a company, I have done enough fraud, and now I simply surrender my DIN and I go away, and now I take another DIN and I become the director of some other company. So whatever frauds I'm doing, I'm never traceable. Can I do that? The answer is no. The answer is no. But supposedly I have unused DIN. Unused DIN. That means, ma'am, how can that be the case? I was being proposed to be appointed as a director in some company, and that's why I made an application in DIR 3 to obtain DIN. I obtained DIN, but in this company, OR was not passed for my appointment, and so I could not be appointed. And thereafter, I have not been appointed in any company as a director, but I have DIN. I know that I'm not going to use this DIN, so I want to surrender this DIN. Can I? Yes, you can. If you have unused DIN, you can surrender that DIN to the government, and the government is going to deactivate your DIN, right? Otherwise we don't get this power. Then what happens, ma'am? RD or central government can cancel or deactivate our DIN. When? If we have duplicate DIN. If our DIN is being obtained in some wrongful manner, that means we have given some misinformation and we have got DIN, or we have got DIN with the intention to deceive someone. In both cases, our DIN can be cancelled. If we die, if we turn out to be of unsound mind, if we turn out to be insolvent, if we surrender our DIN, or if we fail to do KYC. If we fail to do KYC, that can also lead to deactivation of DIN. What is KYC? What is KYC? We have a rule 12A. Earlier you had to read a lot about KYC, not now. What is KYC? Know your customer, right? So know your director. Basically, it is an annual e-verification. Whenever you become a director of some company, every individual who holds DIN, no matter you are a director or you're not a director, you are holding DIN, you have to file this form DIR 3 KYC. And every financial year, there has to be a simple verification DIR 3 KYC web through that, right? So all your records are available. It is an online facility. You just approve the same. Why? Because the government records cannot be updated. We're talking about directors. We're talking about the corporate world. The records cannot be old, right? So they have to be updated from time to time, and the responsibility is being conferred on the person holding DIN. If you have DIN, it's your duty to do that. If you don't go for annual e-verification, your DIN will be deactivated. Fine. Okay, ma'am. We also have another rule, Rule 12, which talks about the changes in DIN. So whenever there is any change, not in DIN exactly, in our details, maybe my address has changed. So it is my duty that I intimate the company within 15 days. Moreover, I file DIR 6. I attach the proof of change. It is verified. That is the DSC of CA, CS, CMA is attached. I submit the form for verification. Central government incorporates all the changes and informs ROC also. Ma'am, why this is happening? Why don't we directly file the form to ROC? See, you are doing an online filing only. So you are filing this DIR 6 also on MCA website, but it goes to the central government and not to the ROC. Why? Supposedly, I am a director in a company of Kolkata, Mumbai, Delhi, Karnataka. So I am a director of 4 companies in 4 different states. To which ROC it will go? So the DIN cell intimates it to the concerned ROCs. Fine, ma'am. Number of directorships. Number of directorships. What do you mean by this? Supposedly, I am an eligible person, I have DIN, and I want to become a director in 50 companies. Can I? Why not? 50 companies. If you have that caliber, why not? Well, this is not like eating a donut eating competition or a puchka eating competition or something like that. It is becoming a director in companies, which requires time, effort, energy, efficiency, everything. And the government itself has given a very generous limit of 20, out of which 10 can be public companies. So if you are a director in 20 companies, you should know that you are highly efficient, like Rajnikant or something, right? You cannot be holding 20 directorships in active companies just like that, right? So we have a limit. What is the limit? Maximum number of directorships in all companies, 20. So I can be a director in maximum 20 companies. But this does not include Section 8 or dormant company, but includes alternate directorship, out of which maximum 10 public company directorships I can hold, right? So if I am a director in 20 companies, and I have 9 public companies and 11 private companies, this is something which is allowed. But 11 public companies and 9 private companies, it is something which is not allowed. Now, when I am computing which is the public company directorship, I have to make sure that I include this also. What is it, ma'am? Private company. Private company which is either a holding to some public company or it is a subsidiary to some public company. This is going to be treated as public company. This is going to be treated as public company for the purpose of, for the section 165, for computing this limit. Okay. Now, supposedly before commencement, there was a person who was a director in 50 companies and there was nothing rule like this. There was no provision like this. When this provision came into picture, he has been given a time period of 1 year, that you choose in which companies you want to stay as a director, and the rest of the companies you have to leave. So you resign in the rest of the companies and you intimate your choices to ROC. Okay, fine, ma'am. But after commencement of act, this is going to be the maximum number of directorships. Now, some companies, they do it that if you want to be the director of my company, you cannot hold more than 10 directorships. Ma'am, can the companies do so? Yes. By passing SR, you can have strict provisions in this regard. So you can reduce the maximum number of directorships. You cannot increase it. You can reduce the maximum number of directorships. Fine. So that was section number 165. Section 164. This talks about the disqualification. See, this section is divided into three parts. Part number 1, that is section 164(1), which talks about 9 grounds of disqualification. If any of the ground of disqualification is attracted to the person, he is disqualified to be appointed in any company as a director. Okay, ma'am. And supposedly, after his appointment, some ground of disqualification is attracted to him, then he has to vacate office according to section 167 of the Act. So we have two different sections. One is for disqualification and other is for vacation, but they go hand in hand undoubtedly. Okay, fine, ma'am. Section 164(2) also talks about 2 grounds of disqualification, but these disqualifications are attracted to the individual because the company in which they are holding directorship has done some default. These disqualifications are attracted to an individual. These disqualifications are attracted to a director. If you are not a director of any company, there is no point of this particular subsection. And section 164(3) talks about additional grounds of disqualification. That is, a private company has been given the power that you can provide additional grounds of disqualification also. Okay, ma'am. Let's read them one by one. First of all, the 9 grounds of disqualification that have been given in section number 164(1). First is unsound mind. It doesn't matter whether I consider myself of unsound mind or not. It is that I have to be declared by the court. Undischarged insolvent. The court has declared you as insolvent, but you have not been discharged yet. So in that period, you are undischarged insolvent. Third, if you have applied for insolvency, but you have not been declared by the court as insolvent or not or solvent, whatever, that means your application is not disposed of yet. You have applied. So during that tenure also, disqualification is attracted to you. Next, if you have been convicted by court, that means you have been found guilty by the court. See, you have done some offense. The offense is moral turpitude or otherwise. You have been found guilty by the court. The court has given you a sentence of imprisonment. The imprisonment is 6 months or more. Imprisonment is 6 months or more. Then you are disqualified for 5 years. Okay. See, if your imprisonment is less than 6 months, you are not disqualified even for a single day. If your imprisonment is 6 months or more, you are disqualified for 5 years. But supposedly the imprisonment is 7 years or more. 7 years or more. Then you are disqualified for life. You can never be appointed as a director in any company. Any company, any time in the future, you cannot be appointed. Fine. Whatever disqualification we are checking is, of course, at the time of appointment of director. So whenever you want to appoint, you check whether the person is of unsound mind, discharged, insolvent, is his application pending, has this disqualification attracted to him. For 5 years, he will be disqualified. 5 years from the date of, not court's order, but from the date of expiry of his sentence. So when he has completed his tenure of imprisonment of 1 year, 6 months, 2 years, whatever it is, after that 5 years, he has been disqualified. After that 5 years, he will be disqualified. Next, court's order. If the court has given you an order that you are disqualified, you are disqualified, simple. Unpaid call till 6 months. Now this is for shareholders. See, a director may be a shareholder, he may not be a shareholder. It's not imperative that he has to be a shareholder only. If he is a shareholder, or if a shareholder wants to become a director, then he has to check this disqualification also. I am a shareholder of the company. The share price of the price of one share is equal to rupee 10. Out of which 6 I have paid to the company, 4 is unpaid. The company calls for this rupee 4 and I fail to repay it. I fail to pay it. Now imagine appointing someone like me as a director who cannot pay her own call money. You think I have the capability to collect other people's call money, to be responsible for the compliances? No, this shows my responsibility, how irresponsible I am, right? But this irresponsibility cannot be checked at the immediate moment, right? So we have been given a time period of 6 months. 6 months. Right. So during the 6 months, if I pay, the disqualification is not attracted to me. The disqualification gets attracted to me when the tenure of, or when the period of 6 months has elapsed from the last day fixed for payment. Okay, then I am disqualified, and this particular disqualification attracts only for company in which call money has not been paid. In which call money has not been paid, and not in other companies. So in other companies, I'm qualified to become a director. Only in this company, I cannot become a director. Now, supposedly you are already a director. So I vacate the directorship according to section 167 and I cannot be reappointed. Reappointed till when? Till I pay this call. Offense under section 188, related party transactions offense. So if I have been found guilty for this offense, I cannot be appointed. Till when? Preceding 5 years. So we check for preceding 5 years. If preceding 5 years this offense is existing, I cannot be appointed. If in preceding 5 years this offense is not existing, I can be appointed. He has not been allotted DIN. Without DIN, you cannot be a director. And if your directorship limit is exceeding 20, you cannot be a director undoubtedly. So on all these 9 grounds, you are disqualified. You cannot be appointed as a director. You cannot be appointed as a director. Fine, ma'am. Then we come to section 164(2). From examination point of view, this is very important, but although it's very small one. Supposedly, I'm a director in some company, and that company fails to file its financial statements or annual return for a continuous period of 3 years. Or it does not pay its deposits, debentures or dividend. They remain unpaid for 1 year or more. Either of the two situation gets attracted, the company becomes a defaulting company. And if I am the director of the defaulting company, I become disqualified. That means if I want to be appointed in some other company, I cannot be appointed. I cannot be appointed. And ma'am, you have to vacate office also from this company? No. This is the catch over here. Not from this company. Not from this company. See, vacation has 8 grounds. If a director is disqualified under any of the ground of section 164(1), he vacates the office. If you are disqualified under section 164(2), then also you vacate the office, but not from the defaulting company. That means if a person is a director in 4 companies, A Limited, B Limited, C Limited, D Limited, and A Limited has not filed its financial statements, the directors of A Limited are disqualified. They cannot be appointed in any other company. And whoever is the director of A Limited is also a director of B, C, D, you have to vacate office, but in A Limited you will continue the office. Right? Because you are responsible for all this. Okay, fine, ma'am. Now, supposedly there is a new director who joins, and before he could actually analyze what's happening in the company, this default gets attracted. And when the default gets attracted, all the directors of the defaulting company, they become disqualified. So Mr. X cannot be appointed in any other company. Oh, very unfair, right? So this disqualification does not apply for 6 months from the date of appointment. So a new director gets the benefit, he gets the time to, he can rectify the defaults, whatever is going on in the company. So he gets a benefit of 6 months. Okay, fine, clear? For this, you also have to give a declaration, the IR 8, that I have told you a number of times. Now, vacation. Grounds of vacation, section 167. First two grounds I've already told you. Third is if the director is absent in all board meetings during 12 months. See, not in the financial year, not in the calendar year. We check for any 12 months, any 12 consecutive months. So the director skips the first board meeting. From there we check for a tenure of 12 months. If he does not attend any board meeting, doesn't matter how many board meetings are held during that particular time, if he does not attend any board meeting, he has to vacate the office. He vacates the office, can he come back? Why not? Because this is not a ground of disqualification. So when we want to reappoint him, when we want to appoint him again, we check the grounds of disqualification. We don't check the grounds of vacation. So again, he can start. These two grounds both relate to one section, section 184. What is section 184? It talks about interested contracts. A director may be interested in some contract. If he is interested, he must disclose it pre-hand to the board of the directors. So he has to disclose it. Moreover, if he is interested, he will stay away from that particular contract. He will not participate in that board meeting. He will not vote, etc., etc. So there are two requirements on part of the director that he has to do. So if you fail to disclose your interest, or if you participate in that meeting of interested contract, both are an offense under section 184. And if you contravene these two, you have to vacate office of director. You have to vacate office of director. Okay, ma'am. Next is if you are disqualified by court. If you are disqualified by court, it is included in this. So you vacate office. If you have done an offense, imprisonment 6 months or more, disqualified, included in this, vacate office. Why? Given separately. Because in such situation, the vacation of office is postponed till disposal of appeal. See, whenever anyone passes a court order against us, we get a time period. What time period? We get certain time period to file an appeal. This is our right. So if court has said that you have done an offense and you are being sentenced to imprisonment for 1 year, this is my fundamental right, I can appeal. And when I appeal, will this disqualification be attracted to me? Do I need to vacate office? What is going to happen? So I have made a beautiful chart for that. Let's discuss this. Order of court. So we have a court order and the court order finds us guilty. I have two choices. I can either file an appeal or I don't file an appeal. If I don't file an appeal, I get a chance to file an appeal within 30 days. If I don't file an appeal, on the 31st day, I vacate. If I file the appeal within 30 days, then I will not vacate office till this appeal is disposed of. See, if the court has declared me as guilty, I am disqualified, I cannot be appointed in any other company, but the directorship that I am holding is going to be delayed if I file the appeal. So I don't have to vacate immediately. I will vacate when the appeal gives its order. Okay, so next court order I receive, I'm not guilty, I don't vacate. And if I am guilty, I again get a chance to file an appeal within 7 days. If I file the appeal within 7 days, if I don't file the appeal within 7 days, I vacate on the expiry of 7th day. But if I file the appeal, again I will not vacate the office till this appeal is disposed of. And after this, I don't have a chance for further appeal. So if I'm guilty, I have to vacate. If I'm not guilty, I'll not vacate. Okay. So that's why these 2 points are given separately. Then, if I am removed in pursuance of the provisions of the Act, Section 169 gives the power to shareholders that they can, by passing ordinary resolution, remove the director. So, if a director is going to be removed, he has to vacate the office undoubtedly. And moreover, if he is appointed by virtue of holding office, if he is the CEO of a subsidiary company and he has been appointed as MD because he is the CEO, if he ceases to be CEO, he will cease to be MD also. Simple. There can be a situation that all the directors have vacated the office. Now, the company again cannot run on its own. So, we need the directors. Where will we go? We will go to the promoters. The promoters will appoint the directors. In their absence, we will go to the central government and central government will appoint the directors. They will hold office till the general meeting, and in general meeting, we will the regular directors can be appointed, or these directors can only be regularized, right? Just like a private company has the power to provide additional grounds of disqualification, it also has the power to provide additional grounds of vacation also. Okay, fine, ma'am. Now, section 161. A very important section, even from examination point of view. It is divided into 4 parts and you have to remember all 4 subsections. Section 161(1), additional directors. 161(2), alternate directors. 161(3), nominee directors, and 161(4), casual vacancy. 161(1), additional directors. Who are additional directors? Anyone. See, if you appoint first directors, if you appoint the directors in general meeting, if you appoint additional, alternate, casual vacancy, whatever type of director you appoint, if you appoint nominee director, if it is appointed by NCLT, whatever it be, one thing is must, or the basic requirements are must. Such person must have DIN, such person must give consent, such person must not be disqualified, and these are basic requirements. Okay, so even when you are appointing someone as additional director, you have to ensure these things. General rule given in section 152 is that the directors will be appointed by the shareholders in general meeting. This is an exception to that. So section 161 here, the appointment is not happening by the shareholders in general meeting, it's happening by the board of directors, right? So the board of directors are appointing here. For additional director, the board of directors can appoint by passing BR, provided they have an authorization in AOA. If AOA is silent, table F can also authorize. Okay, ma'am. So if the board has authorization, they can appoint someone as additional director by passing board resolution. Now this additional director is going to hold office till AGM only. Supposedly AGM is not held, last date on which AGM should have been held. Okay. Supposedly Mr. X, he was proposed in the general meeting and he could not be appointed because his resolution was lost. Now he approached the board of directors and they appointed him as additional director. This is something which is not allowed. Someone who has been rejected by the members cannot be appointed by the board. So a person other than someone who failed to be appointed at general meeting can be appointed as additional director. Alternate director. Alternate director. If a director goes out of India for 3 months or more, right, the board has the power. From where do they get the power? They get the power from either articles of association or through ordinary resolution in general meeting. So if they have this power, they can fill the vacancy of that director by appointing someone else. How? Simply by passing ordinary resolution. Now, he is a replacement. Although you have to understand that alternate director is not a proxy of the original director, he is not the agent of the original director, he is having a separate terms of employment with the company. But it is just that he is appointed to fill that vacancy. So if the original director returns, he vacates. If the term of original director expires, he vacates. So he cannot hold office beyond that particular period. Moreover, a person who is going to be appointed as an alternate director has to be someone who is not already a director of the company. And one person cannot hold alternate directorship for more than 1%. Right? Alternate director is not an agent of the original director. It has its own duties and own liabilities. Okay, ma'am. Section 161(3), nominee director. See, okay, before that, one more point for alternate director. Supposedly, alternate director is a retiring director. He is a rotational director and he has to retire at annual general meeting. So he retires. At annual general meeting, there was no ordinary resolution which was passed for his reappointment or appointing someone else or resolving not to fill the vacancy. So AGM was adjourned. At adjourned AGM also none such resolution was passed. So it leads to automatic reappointment of retiring director. Now this retiring director is out of India and we have in its place an alternate director. So who will be reappointed? Alternate director or original director out of India? Original director out of India. So the reappointment is not automatic. Reappointment does not happen for alternate director. It happens for original director. Okay, ma'am. Now, nominee director. For alternate directors, you have to remember all those basic points, that it does not matter whether the original director is going to out of India for whatever purpose. So the purpose is not important. When he comes back, he has to vacate, right? So all these minute points also we have to remember. And now fine, nominee director. Nominee director, section 161(3). See, the board, if the board gets a nomination, that means supposedly the company has taken loan from a financial institution and they have an agreement that we are going to give you loan only if you allow one person who we are going to nominate to be a part of your board of directors. So financial institution is nominating a person and the board has to appoint that person as a nominee director on their board. Likewise, it can be nominated by central government if they have a shareholding, of course, in a government company. So that is a situation, and it can also be in pursuance of some law. So if the law states or mandates, that is also going to be nominated. So whenever financial institution or other institution or government, they nominate a person by virtue of their shareholding, by virtue of law or by virtue of an agreement, the board, by passing board resolution, appoints such person as a nominee director subject to articles. Clear? Fine, ma'am. Then we have casual vacancy. Casual vacancy is not like intermittent vacancy. The director who has been appointed by the shareholders in general meeting, it is for the director appointed in general meeting and not for the director appointed by board or any other manner. It is for the director appointed in general meeting only. Supposedly his office ends otherwise than in normal course. He was appointed for a tenure of 5 years, but before 5 years only, after the expiry of 2 years, he dies. This is a casual vacancy. This is not intermittent vacancy. Why? Because in intermittent vacancy, it is imperative. It must be filled. Otherwise, it will lead to non-compliance of law. Here, a director has died. It is not non-compliance of law, right? So it may be filled by the board. It may not be filled by the board. Okay. So this is known as casual vacancy. If board has power through articles, it can fill this vacancy. How? By passing a resolution at board meeting. Now, it is a casual vacancy. For 2 years he worked and for remaining 3 years he could not work. So his vacancy is for 3 years only. This is casual vacancy. So whoever fills this position is going to hold office only up to the date which director in whose place he is appointed would have held had he not vacated. That means this particular date. So anyone who is filling the vacancy, casual vacancy, is not going to hold office beyond this tenure, beyond this date. Beyond this date, he cannot hold office. He cannot hold office beyond this particular date. Is that okay? Is that fine? Okay. Now, there is one more requirement in case of casual vacancy, because he is going to hold office for a very long tenure. Say for 3 years, 4 years, 5 years, it could be anything, right? For the remaining tenure, it also needs approval from members. So although board has the power to appoint anyone wherever casual vacancy arises just by passing board resolution, they have to seek subsequent approval from the members also by passing OR in whichever next general meeting comes. Okay? Clear? Fine, ma'am. Now, section 162. Appointment of directors to be voted individually. This section applies not to a private company. It does not apply to a private company. What does this section tells us? It tells us that appointment of a director, two or more directors, appointment of 2 directors or more directors cannot happen by a single resolution. I cannot say that I propose to appoint or resolve that Mr. X and Y be hereby appointed. The members are being deprived of the freedom of choice over here, because either they have to appoint X and Y both, or they have to reject X and Y both, which is not allowed. So for every appointment of director, we must have a separate resolution. Appoint X, yes, no. Appoint Y, yes, no. Appoint X and Y, yes, no. Doesn't work. So separate resolution is something which is allowed for appointment of 2 or more directors. However, single resolution may also work. When ma'am? When can it work? When a prior resolution is passed. That means before this single resolution, another resolution is passed, which tells us, resolve that appointment of X and Y is going to take place by single resolution, whether you approve or you disapprove. So you are taking prior permission from the members for proposing single resolution, and when you obtain this prior permission, it's not going to be OR, it's not going to be SR, it's going to be a resolution with no vote against it. That means there shouldn't be any objection raised to the passing of single resolution. Before single resolution, there has to be another resolution which has to be passed. Okay, fine, ma'am. Supposedly you did not meet these conditions, you did not meet this requirement, and without meeting these requirements, single resolution was passed. Without taking this permission, single resolution was passed. Then all the appointments will be void. And this section 152(7) deemed reappointment shall not apply. We discussed this as an exception. When the retiring director automatically reappoints in adjourned AGM, there is an exception. This is an exception. I told you before only that section 162 does not apply to a private company. It does not apply to a 100% government company and wholly owned subsidiary of such 100% government company. Wholly owned subsidiary of such 100% government company. Okay, ma'am. Section 163. Proportional representation. What is proportional representation? See, if there is being given the power in article, some companies may choose to appoint their directors by proportional representation. Normally what happens, a person is proposed, OR is passed. If we get simple majority, he is appointed as a director. But in PR, we have a special voting method. This is by majority, simple majority. The minority shareholders might have to say that we cannot propose someone, our proportion is not being represented, etc., etc. So we have differential voting methods. What are the three voting methods which are recognized by this section? Single transferable vote, cumulative voting, or otherwise. So you have to remember these three names. The procedures are explained in the regular classes. Now, if your articles permit you, the company may resolve to appoint the directors by proportional representation, right? If you choose PR, then at least 2/3 of your directors are going to be appointed by PR, which cannot be removed by using section 169. Okay, this is an overriding section. So if you choose PR, all other things get stagnant. No rotation, nothing. Okay. The appointment is like the elections. It happens for 5 years, again election will happen. So likewise, here the appointment is happening for 3 years, again after 3 years, again PR. Again after 3 years, again PR. Right? The same people can be appointed, that's not a problem. Okay. Now, this section is again not applicable to 100% government company or wholly owned subsidiary of such government company. The directors who are appointed by using this particular section of proportional representation cannot be removed using section 169. They cannot be removed using section 169. Clear? Okay. Next we have section 168, the resignation of directors, a very simple section. Before we go on to resignation, let me discuss with you, what do the directors do? What are their duties? The directors have to act in accordance with the Companies Act. They have to act in accordance with the articles of the company. They must act in good faith. They should not be negligent towards the company. They should have due diligence. Their interest and the company's interest should be common. They should not ever have a conflict of interest. They should never attempt to have any undue advantage of any situation or gain anything which make secret profit or anything like that, right? And more importantly, prohibited to assign office. This is the most important duty which is covered under section 166 of the Act. Prohibited to assign office. You cannot transfer your office of directorship to anyone else. If you do, or if you do not follow or diligently perform any of the duties of the director, then you can be attracted to a fine starting from 1 lakh to 5 lakh. Right? So all the duties of the directors must be efficiently discharged by the directors who are appointed to the board of the company. Okay. Fine. Now, resignation by director. Director may resign. Director cannot be stopped by anyone else. If it wants to leave the company, he or she may leave the company. What they have to do is, they just have to give a notice in writing to the company, right? The company, it is company's duty to further inform ROC that their director has resigned. So there is a form DIR 12, within 30 days of receiving that resignation, you have to inform ROC. Whenever a director is giving resignation to the company, the resignation is going to be effective from the date when the company receives the resignation or the date you have specified in the notice, whichever is later. So from that date, your resignation will be treated to be effective. Okay, fine. And when the board comes to know about the resignation, they have two duties. They have to intimate ROC, plus they have to also include it in their board's report. As and when it will be made. Now, there is an optional requirement given in section 168 which tells that a director who is resigning may also inform ROC, although it is not this duty of the director who is resigning to inform ROC, it is the duty of the company to inform ROC. But you may also voluntarily inform ROC within 30 days of giving resignation in DIR 11. In DIR 11. Okay, fine, ma'am. Now here also there may be a possible situation that all the directors have resigned. So again we will go to the promoters. The promoters will fill the position of directors, and if it cannot be filled, then the central government is going to take charge, right? Central government will appoint the directors. Next is section 169, which talks about the removal of directors. What happens? Supposedly the board wants to remove any of the director. It cannot. The power to remove director is with the members. How can they do it? By just passing ordinary resolution. Now, removal before expiry of their term, because when their term has expired, they automatically leave and vacate the company. Before the expiry of their term, the members have the power that they can remove the directors, right? But for removing the directors, you must send special notice to the company. And to send special notice, you must be eligible. How do we come to know whether we are eligible to send special notice or not? Section 115, right? So it tells us that the members who are holding at least 1% of voting power or 5 lakh paid up capital in value is eligible member. So if you have the eligibility to send a special notice, send a special notice. This is just a name, nothing very special about it. It's just that this notice has to be sent 14 days before general meeting to the company. General meeting, any meeting, AGM or EGM. This special notice can contain two things. One, remove, we propose, or the intention, we intend to propose for the removal of Mr. X as a director. Point number one. Or it may say, we intend to propose to remove Mr. X as a director and appoint Mr. Y in his place. So there are two situations. One is you just want removal, and the second is you want replacement. So when you want replacement, you suggest a name also. And when you want removal, it's just removal, right? So there can be two probable situations. So you give this special notice to the company. Now what does the company do? The company sends a copy of this notice to the concerned director, for whose removal the notice has been received. This concerned director gives a written representation to the company, what he has to say to its members, right? This written representation is being requested by the company to be forwarded to the members. But what happens sometimes? The directors, the concerned director tries to misuse this power. He has been given an opportunity that he can convey his message to the members. But instead of using this opportunity, he is misusing the power and writing all the bad things that he can about the company, about its directors, about its management, etc., etc. Now, when the written representation reaches to the company reads it, they get disturbed and they feel that how can we let this be circulated to our members? So to seek a solution, they may move to tribunal. So they make an application and they say that we understand that the director has a right to make a representation, but such type of representations that he is making cannot be circulated. So the tribunal might order that there is no need for circulation of this written representation or reading it out at the meeting, right? So in such case, this written representation may not be circulated. Otherwise, it will be circulated. Fine. So eligible member sends special notice to the company forwards the copy to director gives written representation to the company sends written representation plus notice 7 days before general meeting to the members. Quite possible there is time constraint or any other thing, and the meeting and the notice as well as the representation could not be sent, so it will be read out at the meeting. That's not a problem. And quite possible it is sent. Whatever the case be, general meeting is held. By passing OR, the director can be removed. Now, when he is removed before the expiry of his terms, it again leads to vacancy which has been created, right? Ideally, this is a case of casual vacancy, but supposedly we got the special notice of replacement and Mr. Y's name was also proposed. So, by passing OR, Mr. Y can be appointed. Supposedly, he was not appointed or no name was proposed. Then it will amount to casual vacancy which can be filled by the board by using section 161(4). Okay. So, we are removing directors just by passing OR. There are certain type of directors which cannot be removed by OR. What type of directors? Director who has been appointed by the tribunal, the director who has been appointed by proportional representation, the nominee director, and see, independent director, he is appointed for 5 years by passing OR. He can be removed by OR. He is appointed again for 5 years, that means for his second term, by passing SR. He can be removed also only by passing SR. He can be removed also only by passing SR. So, independent director in second term removal requires SR. Clear? Okay. Now, broadly we have completed the chapter and we are left with two important topics, independent director and SSD. Before that, section 170. What is 170? It tells about the maintenance of register. So, every company has to maintain a register of directors as well as KMP. This is going to be maintained at the registered office, which shall also be open for inspection by the members according to section 171. They can inspect this. It will also be available in every annual general meeting where members can come and see it. They can take extracts. It is company's duty to provide extracts within 30 days. If you fail to do so, an application can be made to ROC and ROC will order you immediate provision of the same, right? So that is something. Section 171 talks about inspection. Section 170 talks about maintenance of register. Apart from maintenance of register, section 170 also talks about DIR 12. That whenever you appoint a director or whenever there is a change in director or KMP, file DIR 12 within 30 days. Section 170 as well as 171, they both are not applicable to government companies. Section 172, this talks about punishment. So if you contravene section 149 to 171 and there is no specific punishment provided in that particular section, example, non-maintenance of register, non-appointment of woman director, all this is, no specific punishment is given in that respective section. So you follow the punishment of leftover section, that is section 172, which states that minimum penalty 50,000, 500 per day continuing default, and maximum penalty 3 lakh and 1 lakh. 3 lakh for company, 1 lakh for officer in default. Okay, 3 lakh for company and 1 lakh for officer in default. Clear? Now we move to independent directors. Who are independent directors? someone who is a highly experienced, highly knowledgeable person and who is not connected with the company. So when he comes to the company, he brings high level of expertise, and since he is not connected with the company, he will bring an unbiased opinion. We don't need independent directors in all types of companies. They are needed in certain limited companies. Listed company, if it's listed, we don't need to check any threshold. Listed companies straight away have to have 1/3 of their directors to be independent. If it's not listed, we have to check 3 criteria: 10, 100 and 50. Paid up capital more than equal to 10 crores, turnover more than equal to 100 crores, or loans, debentures, deposits more than not more than equal to more than 50 crores. If either of these 3 criteria is satisfied, then you have to appoint 2 independent directors, at least 2 independent directors. Okay. So every listed company, at least 1/3 independent directors, and unlisted public company, if you meet the threshold, at least 2 independent directors. Whatever independent directors you are appointing have to be subject to the requirement of audit committee, NRC, any other law. That means if audit committee says you need 4 directors, independent directors, and this section says 2, appoint 4. Okay. Supposedly, the company is an unlisted public company and has crossed the turnover of 100 crores. So 150 crores is the turnover, you appoint independent director. Next year, the turnover comes down below 100 crore. Again below 100 crore, again below 100 crore. So if for constant 3 years you fail to meet that threshold, then there is no requirement for appointment of independent director. There is no requirement for appointment of independent director. Just like the vacancy in the office of woman director is filled immediate next board meeting or 3 months, whichever is later, like that here also the intermittent vacancy which is created in the office of independent director has to be filled up immediate next board meeting or 3 months, whichever is later. To appoint anyone as independent director, what is needed is the person should be an individual. He should not be disqualified. He should have given in. He should have given consent. He should meet the criteria of independence given under section 149(6). Apart from all that, and his name should be included in the data bank. What is this? We will read it a little later. Okay, so all these requirements, if they are fulfilled, then his name can be proposed, and when his name is proposed, he is appointed in the general meeting by passing ordinary resolution. Okay, ma'am. To be an independent director, independent director comes under the category of non-executive director. So you cannot be MD or whole-time director or nominee director. You cannot be these 3. And if you are not these 3, then if you meet the criteria of independence, you can be appointed as independent director. So not MD, not WTD, not nominee director, and satisfying all conditions below can be appointed as independent director. Point number 1. He should be the person of integrity, experience and expertise. Not in our opinion, but in the opinion of board. If it is a government company, in the opinion of respective ministry. He should not be the promoter of company holding subsidiary associate. This you can call as CHSA, this you can call as cash, this you can call as group, however you may learn it. Not related to PD, that is promoter director of cash, PD of cash. Someone should not have a pecuniary relationship, that is a monetary relationship with cash or with PD of cash during preceding year or 2 preceding years, during financial year or preceding 2 years. Now this has an exception. It is quite relaxed that if your pecuniary relationship does not exceed 10% of total income, it's okay, you may have it. Still you will satisfy the criteria of independence, right? Still you will satisfy the criteria of independence, integrity, experience and expertise, not related to PD of cash and not a promoter, not having a pecuniary relationship. So these are the first 3 clauses, easy ones. Then comes D, which is for the relatives. So your relative should not be holding security in cash, that is CHSA. Your relative should not be holding security in CHSA. There is a limit that if it holds security up to 50 lakh or 2% of paid up capital, it is allowed. Your relative should not be indebted to CHSA or PD of CHSA. If it is indebted in amount of less than equal to 50 lakhs, it is allowed. Your relative should not give guarantee to CHSA or promoter of CHSA or director of H. If it gives a guarantee for an amount less than 50 lakhs, it's okay. It's okay. You can write for an amount of 50 lakhs or more. Right? It's okay. Your relative should not have a pecuniary relationship with CHSA. For an amount 2% or more of turnover or total income. Pecuniary relationship, again monetary relationship. We have done a detailed discussion on all these points, right? So now I think you are well in a situation that you can quickly recall this, and this is learnt by you, right? Okay, so clause D was for relatives, 4 points. Not holding security, 50 lakh, 2% paid up capital, not indebted in excess of 50 lakhs, not guarantee for 50 lakhs or more, no pecuniary relationship, 2% or more of turnover or total income, right? So these are the 4 points for relative. Now, you or your relative should not have been a KMP or employee in CHSA preceding 3 financial years. However, relative may have been an employee. You or your relative should not have been employee, proprietor or partner in audit firm of CHSA, CS firm of CHSA, cost auditor firm of CHSA, or such a legal firm which is getting 10 or more % of its total income from CHSA, right, in preceding 3 financial years. You with your relative should not hold more than 2% of the voting power of company. You with your relative, you or your relative should not be a director or executive of such NPO which is getting 25% or more of its receipts from CHSA or the director or promoter of the company, or holds 2% or more voting power. Who possesses other qualification as prescribed? What are the other qualification prescribed? You can be an expert in finance, you can be an expert in law, management, sales, marketing, administration, research, any other discipline, etc., etc. Fine. Now, every person who is going to be appointed as an independent director must give a declaration that yes, he has fulfilled the criteria of independence. So whenever you are appointed as independent director, in the first board meeting that you participate, in the board meeting of every financial year, and wherever there is a change in circumstance, you have to give a declaration. It is your duty. We have a code, Schedule 4, code for independent directors, how independent directors must react to the situations, how they should behave. You must follow that. You must follow that. What will you get? because you cannot get salary, you are not an employee. You would get profit related commission. Even if there is no profit in the company, then also you will get commission, then also you will get some amount, you will get sitting fees, right? You will get reimbursement of expenses, okay? But you will not be entitled to stock option. That is one thing that you need to remember. You will be appointed for 5 years, for 5 years. You may be appointed for a shorter term also, but you cannot be appointed for more than 2 consecutive terms. And any term shorter than 5 years will also be treated as one term only. So here you can be appointed for 5 years by passing OR, again for 5 years by passing SR, and then you need to have a cooling period. Then you need to have a cooling period for 3 years. Cooling period for 3 years. Again you can be appointed for 5 years. Okay, during the second term, if the company's shareholder want the independent director to be removed, they have to pass SR for removal. OR will not suffice. OR will not suffice. Okay. Now, whoever is the independent director or any non-executive director, he cannot be held liable for everything that's happening in the company. He will be liable only for those acts where he has given his consent, he had knowledge, or he had not acted diligently. Only for those cases he will be responsible. Only for those cases he will be responsible. Independent directors don't retire by rotation. Don't retire by rotation. Now, as I told you about data bank, right? What is data bank? Section 150. Section 150 basically tells us about data bank, that central government, see, every company, it is mandatory for listed companies and the companies which are meeting this criteria, it is mandatory for them to appoint independent directors. From where will they get these independent directors? For which central government has maintained a data bank. Now this data bank has been maintained by the notified institute of government. What is the notified institute of government? Indian Institute of Corporate Affairs has been notified by central government. So any company who wants independent director, they can go to that data bank, they can select a person, they have to perform their own due diligence, and if he meets all the criteria of independence of your company, etc., etc., you may appoint such a person as independent director. Fine. Okay, ma'am. Now we have a rule 6. If I want to be the independent director, or I have been the independent director, I have to comply with this rule 6. What does it tell us? What does it tell me? That I cannot be an independent director unless my name is included in the data bank which is maintained by this institute. How do I include my name, ma'am? I have to make an application to the institute along with the relevant fees, and my name will be included. Okay. That means before this rule came into picture, there were many independent directors. They also have to include their name. Yes. They have been given a time period of 13 months within which they can apply to the institute for inclusion of their name along with the fees. The name can be included for 1 year, 5 year, or for lifetime. And after this rule, anyone who wants to be appointed as an independent director, that means some companies proposing you to be appointed as independent director, you must before your appointment include your name in the data bank. And supposedly I'm not being appointed by anyone as independent director yet. I find this as a career opportunity and I want to include my name voluntarily. I don't even have DIN. I'm not a director of anyone. Can I? Yes, you can. So voluntarily also you can apply for your name as an inclusion in the data bank. Now, when you apply for your name as an inclusion in data bank, within 2 years you have to pass a test. Online Proficiency Self-Assessment Test, OPSAT. With 50% passing criteria, there is no limit on the number of attempts. So within 2 years, you have to pass it. You have n number of times. So within 2 years, you can appear for the test n number of times and you can pass this test. You have to. If you don't pass it, your name will be removed from this particular data bank. If you pass it, great. Supposedly you enrolled your name for 5 years only. The tenure expires. Within 30 days, you can renew it. If you don't renew it, your name will be removed. Fine. Now, what has to be, what else is there in this rule which needs to be remembered is the exemption. What exemption, ma'am? Now, some very proficient people are not required to appear for their test. They will apply to the institute for inclusion of their name, and this step is excluded. They don't have to appear for their test. Who, ma'am? Someone who has 3 years of experience as a director or KMP in listed public company, unlisted public company with paid up capital to 10 crores or more, in any body corporate which is listed either in India or in such a country which is a member of FATF or IOSCO. Any body corporate which is incorporated outside India but having paid up capital more than equal to $2 million US. Any other statutory corporation. Or if you have 3 years experience in the pay scale of director or above in the Ministry of Corporate Affairs, Ministry of Heavy Industries, Ministry of Public Enterprises, Ministry of Commerce, etc. Right? Or if you have been in the pay scale of chief manager or above in SEBI, IRDA, RBI, PFRDA, so all these are excluded from appearing for test. Moreover, if you are an advocate in practice, if you are a CA in practice, if you are a CS in practice, if you are a CMA in practice, and you've been practice for 10 years, at least 10 years, then also you are exempted from the test. Then also you are exempted from the test. Okay? Fine. And this is probably the last section that we have to discuss, that we have to revise. We've covered all the sections. SSD, Small Shareholders Director. Who are SSD? SSD. The directors who are elected by the small shareholders. Who are small shareholders? Small shareholders are the shareholders who have less than or equal to 20,000 face value of shares of the company. So they are considered as small shareholders. Now this section applies to listed company and it is discretionary. It's not mandatory. So if a listed company wants, it may suo motu, that means on its own or on receipt of a notice by the eligible small shareholders, it can have one SSD who is elected as who is elected by small shareholders. Who is eligible to send notice? 1,000 small shareholders or 1/10 of small shareholders, whichever is lower. Right. So they will send a notice to the company that we are proposing the appointment of this person as SSD. And this is his DIN, this is his consent, and he has given a declaration that he is not disqualified, right? So along with these details, they send a notice to listed company. Listed company may have one director elected by SSH. Now this is not a normal election which is happening by all the shareholders. So it's not an ordinary resolution in general meeting. It is the election by small shareholders only. So they meet. Only their meeting happens, and in their meeting by majority votes such a person is elected who is going to be non-rotational, who is going to be independent. So he also has to meet the criteria of independence, section 149(6), and he also has to give a declaration in that regard. Okay, and he is going to be non-rotational. He has a fixed term for 3 years. Can he be reappointed after 3 years? No. Then 3 years will be cooling. Again, then he can be appointed after 3 years. During the schooling period, he cannot be appointed or be associated in the company in any manner. in any manner. Okay, fine. If small shareholders director, someone who is appointed as SSD, is disqualified under section 164 or grounds of vacation are attracted to him, or he fails to meet the criteria of independence, he has to vacate the office. One person can be SSD in maximum 2 companies, but the 2 companies should not be competing business, should not be in the competing business, okay, or their business should not be in conflict with each other, okay. And no reappointment allowed, that is something that I've already told you. SSD can be removed under section 169. This is something which is allowed. SSD can be removed under section 169, right? So I think we have revised everything. Okay.